Good morning, my lord. Your lordship gave me 5 minutes, and I am going to be just as quick as I can. I may go a little beyond 5 minutes.
Okay, we don't argue about the 5 minutes.
I won't.
Just
My lord, I'm very grateful.
submissions.
I put it this way, my lord, I'm not going to suggest any procedural unfairness.
No.
My lord, I have, firstly, just the point that my learned friend, Mr de la Mare, produced what I think your lordship called a profusion of authorities, and I cannot even begin to respond to each of them. If there are any particular authorities on which the court feels it might be valuable to have an observation, I would be very happy to do that and to supply any observations in writing.
I really think no need.
I'm obliged for that, my lord. My lord, on the second point about authorities, if the court could look at page 16 in the core bundle, page 169.30.
So you're going to have to give me the page again. 169.
169.30. It's the Spain's. It's the written observations of the European Commission. And it's at footnote 11. Can you see that?
Yes.
There are references to 2 cases, Nordsee and Achmea. Now, when preparing the bundles of authorities, we were, and I hope understandably, trying to keep the authorities that you were confronted with to a minimum. But there are, in those 2 cases, there is, in the light of what was said by Mr de la Mare, some importance, because the Nordsee case, which is not in the bundle, but which will be made available to the court, at paragraph 14, the Court of Justice held that EU law must be observed in its entirety throughout the territory of all member states. And parties to a contract cannot create exceptions to that. Now, given that what we are examining is, as it were, the legitimate limits of public policy in Article 34(1), I would respectfully suggest that that is something which the court should bear in mind when considering what English public policy is and what the limits are imposed by European law. And the second case, Romatska, is perhaps not entirely.
My lord, my ladies, just so in case it's helpful, the authority is in the bundles. It's in the arbitration appeal bundles.
Ah, that's why
it's in bundle B, tab 59, page 1562.
I'm very, as ever, I'm grateful to my learned friend. And the second case is Romatska, which is not in the isn't apparently in the bundles. I'm afraid I've been concentrating my fire on the regulation field, and this is perhaps not unimportant. An award cannot be recognised or enforced if it is contrary to EU law so to do, and that's paragraphs 42 and 43. And the Achmea case, which we'll also make available, is that a commercial arbitration award has to be considered by member state judges paying suitable respect to the fundamental rules of EU law. So the question is, what are the fundamental rules of EU law? And it's my submission that the Court of Justice's judgment in the present case, whilst it doesn't actually utter the words res judicata arising out of an award, it is completely incomprehensible unless that proposition is understood as being inherent in the judgment. Now, one may criticise the judgment for all sorts of things, but I suggest it's completely incoherent, and it's incoherent for this reason. The premise of the whole consideration by the Court of Justice was that there is an award in existence which is rendered a judgment of the court of a member state by a process, either Section 66 or some other process. And that judgment is otherwise irreconcilable with the incoming judgment, but is not available as an irreconcilable judgment under Article 34.3. So, by definition, the whole analysis is premised upon the prior existence of what one might call an irreconcilable award. An irreconcilable award under which is not capable of generating an Article 34.1 exception, because if it were, everything that the Court of Justice has said about judgments is completely meaningless, of no assistance, and sends the wrong message. It is all inherently and necessarily so the case that the award itself, the irreconcilable award, does not provide an exception. If it did, the Court of Justice would simply have said, well, this is all very interesting about judgments, but if there's an irreconcilable award, then that's capable of falling within public policy, which was question 3. So it does mean that in every case considered by the Court of Justice, if an award can create an irreconcilable judgment under res judicata, then it will always be an Article 34.1 point. And that is completely at odds with the analysis of the court, who were intent on applying the objectives of the regulation. So the entire judgment is premised upon awards not achieving the effect of a 34.1 exception, which was itself the premise of Mr. Justice Hamblin's own judgment in thinking there was utility in giving the Section 67 judgment, because he said you shouldn't deprive the club of the full benefit of the award. Now, if the club already had the full benefit of the award under Article 34.1, then by definition there was no utility. So it's not only the inevitable necessary assumption of the Court of Justice that res judicatas arising out of awards cannot fall within the true meaning of Article 34.1. It was the necessary assumption of Mr. Justice Hamblin, thus creating its own internal issue estoppel.
I think, Mr. Young, you've already said this at great length.
I've said, my lady, I said the second point. I don't know whether at great length or not.
I'm thinking
comment.
about the last few days, not
Yes. But the point is that the Court of Justice's judgment is incapable of being fairly read. If
Well, I mean, you have said that.
Yes, I've said
times,
that.
Not only this.
No, I've said that, but it's incapable of being fairly read because it makes the whole thing pointless.
Yeah,
and
well, you've said that too.
Yes, my lord. The next point, my lord, is this: what is the issue estoppel arising from the award. And I think one does have to be just rather precise as to what the judge thought the issue estoppel was and what indeed the club say the issue estoppel was. And there was a bit of brain fog on my part yesterday. Your lordship asked me about res judicata as to the existence of the obligation to arbitrate. And I could not agree more. That was decided by the court, by the arbitrators, and that was res judicata as to the obligation to arbitrate. But that does not necessarily generate public policy, because the English public policy does not so prescribe. That is why we have Section 9 of the Arbitration Act, which gives a right to a stay of proceedings. And we know that under certain circumstances, with certain procedural limitations, that was also available in Spain. So to that extent, yes, there was an issue estoppel, but by definition, it cannot be a matter of English public policy, because if it were English public policy, then Section 9 of the Arbitration Act would be completely irrelevant and wrong. The second element of the award was that the club is not liable in the absence of prior payment. Now, the point, and this is, can I ask the court to look at the judgment of the learned judge at para 2552, which it's at page 276 of the bundle. I'm sorry. Sorry.
Core 9.
Oh, core. The club's argument, Mr. Justice Butcher says at 2552, was the Schaff Award and also the English Section 66 judgments have decided that the club is not liable to Spain. These decisions give rise to a res judicata. And that was how the learned judge so held at ultimately at paragraph 290. Now, and that is how the issue estoppel is configured by my learned friend in his skeleton at in his first skeleton, which is at page, I think, 135. I'm afraid my pagination went slightly awry. In his skeleton, at paragraph 100, it's tab 4. Is that right? Schaff
Paragraph
Award.
100 of the skeleton.
Yes. The judge further set aside the registration order on the ground that the Spanish judgment conflicted with the English public policy pursuant to 34.1 of the regulation by reason of the res judicata arising from the Schaff Award, which declared that the club is under no liability to Spain in relation to its claims on the policy. So the res judicata, which was considered by the learned judge and developed by the club, was not in relation to the arbitration agreement, but in relation to the pay to be paid. Now, what the learned arbitrator and Mr. Justice Hamblin did was reflect the fact that the club was not liable in the absence of prior payment. So it was not a final definitive determination of non-liability. And it therefore lacked finality, because there could be circumstances where that condition of prior payment might no longer persist. And as I've told you, the court, how circumstances could arise. Now, what you cannot do under an article, for the purposes of Article 34, is look at the substance of the incoming judgment. Article 36 says that in the clearest of terms. So you can't ask yourself, what was the reason for the pay to be paid clause not applying? So there's no finality. For the purposes of issue estoppel, you need finality as to the liability of the club, and there is no legitimate reason for questioning the correctness of the Spanish court. Now, I accept that we did not go through the hoops of purchasing an assignment of rights, but it's not impossible. But you, under Article 36, are not entitled to consider the incoming judgment. So not only is the judgment, the award of Mr Schaff, not final or definitive, and thus not capable of creating a res judicata, because it's not final, but also it's one that is expressly excluded when you are looking at Article 36. So there is no res judicata that is available, even if res judicata is otherwise capable of being within the ambit of 34.1 public policy, which it isn't, for reasons that I have explained at length or otherwise. And you will look in...
My lord, my ladies, I hesitate to interrupt Mr Young 5 minutes, but these are not reply points.
No.
He has referred your, my lord and my ladies, to a decision which is not only not in the bundles, but is extremely controversial, the Achmea case, not referred to in my submissions at all, not referred to in any notice of appeal, not referred to the judge, not dealt with by the judge. The arguments that he's now actually running were actually raised before the judge. The judge dealt with them and rejected them.
Well,
At paragraphs 89 to 103 of his judgment, there is no appeal from those findings.
no, with the greatest respect, a learned friend would give me that. The learned judge considered it in the context of whether there was irreconcilability. But if it's not an irreconcilable judgment, that doesn't matter. The point I am making is an analytically different one, and it is that the meaning of public policy is confined. And there is some suggestion that, I think my learned friend suggested that my argument meant bringing arbitration and res judicata arising from arbitration within the regulation illegitimately because of the arbitration exception. I say that's not right. I say it is excluded from the regulation and from Article 34.1 on the coattails of public policy, which is it's a different question. Anyway, but that is my submission is that there was no finality sufficient to create an English res judicata, and an English res judicata arising from an award is not within public policy exception, as Jennard said in 1968. So, and I will move on.
Well, I mean, you're moving on now, You've now been on your feet 25 minutes.
My Lord, can I just give your Lordship just a couple of very short points, mostly down to the, no, entirely down to the industry of my learned junior. And it's a short point, and it's just give you some references. Transcript day 2, page 152, lines 6 to 21, Mr. de la Mare said, broadly speaking, that if the analysis at paragraphs 54 to 58 of the judgment had ever been put to the club, they would have done certain things. Then he gave 4 examples of what would have been done. Well, as to the points that he raised, the club's written observations before the CJEU did in fact make all of those points. If you look at supplementary page 1200, paragraph 35.4, and supplementary page 1205, paragraph 41, you will see those points being made. They just weren't made to the satisfaction of the court. But I'm grateful to the industry of Miss Patel for identifying that. The last point, simply this. It is said that there's no right of re-referral. And actually, I say it's the last point. There is just a couple of references, if I may give them to you. On procedural unfairness, can I just direct your attention to Broberg and Fenger at tab 120, bundle, I think it's bundle 6, at page 3202, and the comments of Francis Jacobs, the Advocate General in Prussian Electricity, in Authorities tab 53 to 68, which set out the procedural rules applicable in the case of a preliminary reference, which make the point that it's absolutely not adversarial, and the same principles don't in here. And the point is that the court can reopen, and there can be a re-referral. Now, in this case, obviously, because of the probably the unintended consequences of Brexit, I don't know, there's no direct right of re-referral, but there is a right for...
I mean, this is really testing the court's patience.
My Lord, I do not wish
the
to...
The re-referral point was full square made 20 times yesterday. You had your opportunity to reply. You're now saying the same things you've said before about whether or not re-referral is negated by Brexit or not Brexit.
No,
I mean,
how
is this helping?
My Lord, the last thing I wish to do is trespass upon your Lordship's precious time. But one has to remember that...
Patience. Patience is very precious.
Patience is golden.
Yes.
My Lord, just to say...
Legendary, Mr. Young.
I've known that for so long, my
yes.
Lord, legendary, that there is within the withdrawal agreement the power for infringement proceedings to be commenced against the UK. That goes to the arbitration procedure set up under the withdrawal agreement, and questions of European law can be referred then to the CJEU. So by a rather indirect route, there can be a return to the CJEU, albeit that it may result in the UK carrying a liability rather than the club. But there is a right to which I don't suppose Mrs. Reeves would necessarily think it was desirable that public policy achieve that. But there is the possibility for the CJEU to become re-engaged. I will now say no more. I've trespassed upon your Lordship's patience and upon your Ladyship's patience, and I'm going to sit down.
Thank you. Now, I know Mr. Hancock and Mr. de la Mare are going to tell me that you've raised new cases,
yes,
and you want to have an opportunity to reply to them. Can I allow Ms Norris to speak first?
Yes, I was actually just going to make the point that your lordship has just made, i.e. that new cases have been raised. I'm not in a position to deal with those new cases because they're not in any notice of appeal, nor are they in any skeleton argument that has ever been served by Spain. And they are therefore, and then not matters for which permission to appeal was given by the learned judge. They're therefore not matters which are open.
That may be good enough.
That may be good enough. And that's why I rise now for just a minute before handing over to Miss Norris.
Thank you. Well, good morning, Miss Norris.
Good morning. My lord, my ladies, on the core issue of the proper interpretation of the withdrawal agreement, we have heard the club's position that this court need not be troubled by the ordinary meaning of the terms in Article 89 of the withdrawal agreement because it simply does not apply. Their case being that a national court may indeed review the exercise of jurisdiction of the Court of Justice, and therefore we never end up there. I will not repeat my submissions on the withdrawal agreement from Wednesday. We stand behind them. My point, however, is that the whole premise of that position is misconceived. The Court of Justice of the European Union did nothing other than rule on the substance of the question that was asked. And to support this, I make 2 points concerning the nature of a preliminary reference. Now, counsel for the club referred repeatedly to the notion of a generic reference. The Commission has some reservations about the use of this term because a reference is always made in a factual context. A question could never be formulated in a purely abstract manner, and the question could never have been about a Section 66 judgment in general. Had it been so, it would have been inadmissible. And this is covered in my written observations at paragraph 65 to 66. And this has other implications. One is that a national court cannot formulate a question in such a way as to try to carve out issues of European Union law that it does not wish the Court of Justice to refer to. The Court of Justice, in its very broad jurisdiction to rule on European Union law, and as the authoritative arbiter of what European Union law is, may decide which aspects of Union law it considers to be relevant to answer a question. Second,
and always does.
And does, indeed, my lord. The second point is that even if questions are posed in a binary way, this does not constrain the Court of Justice to answering them in a binary way. And my lord, as you said yesterday afternoon, replying to a question with a yes, but is not an exceptional practice of the Court of Justice of the European Union, and it is certainly not a practice which has been confined exclusively to this case. And in the voluminous bundles of authorities surrounding you, there are some examples of this. Perhaps I will just refer you to 2 of them. One is behind bundle tab 98. It's the case of Vueling. That was referred to by counsel to the club yesterday for an entirely different proposition concerning the effectiveness of union law. If you would like me to take you through them, I can, but perhaps it would suffice to say that the questions asked appear at page 2642, and the qualified answer given is at page 2653. The Commission relies on that authority simply to show, and there are other examples as well, that this yes but answer is anything but exceptional. Therefore, although the Court of Justice of the European Union gave a qualified answer in this case, that does not show that there was an inappropriate extension of substance, and moreover it is completely irrelevant that the Advocate General gave a binary answer, in the sense that the Court of Justice is not bound to do the same. We also took careful note of the submissions concerning so-called frozen conflicts. We take issue with a lot of what has been
Sorry,
said
what was the submission about? Frozen.
frozen conflicts of competence.
Oh, frozen.
We take issue with much of what has been said in that respect, but we also say it is a complete red herring. And here, if I may repeat some of what I said on Wednesday, because it is a matter of importance. Article 86 of the withdrawal agreement preserves the role of the national court as the jurisdiction with the task of applying union law, as interpreted by the Court of Justice, to the facts of the dispute before it, as it finds those facts to be. There is no basis and there is no need to read into Article 86 or 89 the implied powers which counsel for the club seeks to encourage you to do. However, if the National Court considers union law is applicable, it must apply union law as interpreted. And here I would add one further point. A reference is only admissible if a national judge considers it necessary. Necessary in the sense that it is capable of being relevant to the matter before them. It would be extremely rare for such a question to be referred, only for a court subsequently to conclude that no reference was ever required. And this explains why rulings must be given their effect in the legal order of the referring court and should not be lightly circumvented or otherwise avoided.
There's a wrinkle, of course, in the present case, which is that the Superior Court considered a reference wasn't necessary.
My lady, the judgment of the Court of Justice of the European Union was handed down while it had jurisdiction to do so, and that jurisdiction was not removed. And in that sense, it is binding, and the subsequent decision as to whether the reference should have been made does not detract from the jurisdiction which the Court of Justice exercised.
And it moved quite speedily as to achieve that.
My lady, if I may just, I'm sorry. What happened was the court.
I'm aware of what happened, Mr. Young. I think Mr. Norris ought
Yes,
to be
yes, yeah.
given an opportunity to address.
No, of course. But you.
Well, thank you,
It's
my
not gonna be
lady. In
polite.
that case, if I may continue my submissions, briefly on the question of Article 34(1). This court is confronted with two comparatively stark positions. On the one hand, it is argued that the Court of Justice has not decided, whether intentionally or otherwise, the question of the arbitral award itself. And the alternative submission is that it has implicitly decided on both. The European Commission invites this court, to read the judgment purposively. It would say that at paragraph 40 of the judgment, the questions referred were reproduced. They were reformulated in paragraph 74, and point 2 of the operative part should be read in light of the same. And the reason we say this, and I paraphrase a little some positions that came from the bench when describing, I believe, the high point, as it was put by Lady Justice Andrews, of my learned friend's submission, is that the consequences and considerations described by the court in its reasoning at paragraph 60 to 64 would apply to the arbitral award as they would to the judgment recognising the giving effect to the arbitral award. And the other reason to refer to something that my lord said is that one must read the judgment purposively, and it would not have been logical for the court to reason in a way that would effectively create a huge loophole. And it certainly cannot be said, if one reads the judgment as a whole, that it intended that to be the effect. My lord, in a case in which the parties have been in some disagreement for some years, there appears to be consensus on one further point. On Wednesday, the respondents criticised the Commission for not having addressed points on procedural fairness, and yesterday, Mr Young for Spain made the rather bold submission that the Commission would be making submissions on those points. In our opening oral observations, we explained the nature and reasons for the topics which we have addressed. Nevertheless, we have heard some rather extraordinary submissions concerning the Court of Justice of the European Union. And therefore, whilst this is not in our written observations, I would in fact be delighted to clarify certain points concerning procedural fairness. Evidently, and I emphasise this, evidently, Article 47 of the Charter applies to the preliminary ruling process before the Court of Justice of the European Union. That is a court which has shown itself to have considerable attachment to the rule of law and to uphold fundamental rights. Those rights are not diluted, less important in a preliminary ruling procedure. They apply. And we wish to be extremely clear on that particular point. The second point we would make, however, is that how they are given effect and how they are expressed may evidently vary depending on the precise procedure. A preliminary ruling is non-adversarial, and terminology matters. There were lots of references to terminology. There are no parties as such in a preliminary ruling procedure. There are participants who may make observations under Article 96 of the Rules of Procedure, and they are behind your core bundle, tab 11, Article 96. And in that sense, yes, it is different to a direct action when we do speak of adversarial parties. And it's different because the role of the preliminary ruling procedure is this dialogue between the courts and not a dialogue between the parties as to the merits of their underlying case. The second point I would make is that written observations are limited, and they are limited in all proceedings, to 20 pages. And this is set out behind bundle tab 12, still the core bundle. You will find the practice direction of the Court of Justice. And I would in particular draw your attention to paragraphs 9 to 12. And these appear on page 0264 to 0265. So yes, those written observations are limited to 20 pages, but one is not required to address the facts. One does not necessarily have to refer to cases in the same way. These are specificities of pleading before that jurisdiction. And the final point on this, and here I do say it is of some significance, and I would invite you to turn to page to tab 15 of the core supplementary bundle, concerns the roles of measures of organisation. And here there appear to have been some misconceptions. At page 153, you have the measures of organisation that were handed down in these particular proceedings. Annex 1 says, and I read, in their replies to the first and second questions, ... It does not say the party should only make oral observations on questions 1 and 2. It says in their replies to the first and second questions. The second point is that those measures of organisation say that the parties should focus their arguments, and here I quote, on whether the objectives underlying regulation number 44/2001, and so on. On the objectives, my lord, my ladies, on the objectives. That point was in the formulation of that instruction. And the word focus is important as well. Measures. You would like me to read the whole?
Yes.
The full citation is to focus their arguments on whether the objectives underlying regulation number 44/2001 require an order of a national court to be excluded from the scope of that regulation merely because, in substance, it is entered in the terms of an arbitration award. The point that the Commission makes is that there is a reference to the objectives of the regulation. And that is reasoning which is then played out in the judgment of the court, which referred to the objectives of the regulation. And the reason we say this is...
You wouldn't disagree, would you, that anybody reading that is being directed in relation to the first and second questions to focus on whether the objectives are effectively compatible. In other words, it's in accordance with the objectives that the order be excluded because it is in substance entered in the terms of an arbitral award. That's what it says.
My lady, no, but our point is that by referring to the objectives, the court was inviting the parties to consider the role of the objectives more generally. And the further point is that although oral observations, the court often directs the parties to focus on certain issues, it does not preclude the parties from referring to other points. The function of an oral hearing before the Court of Justice of the European Union is to afford parties the opportunity to address points, including the submissions of other parties with which they may not agree. And that is part of the procedure which guarantees the fairness. Now, it is perfectly true that before the Court of the Justice of the European Union, there is not the same system of oral advocacy as there is before this court. Parties are not indulged with several hours to make submissions. And that seems to be a very appropriate moment for me to bring my submissions before this court to a hopefully timely close. So unless I can assist you any further, my lord, those are the observations.
Very timely, Miss Vires. Thank you very much.
My lord, I'm going to wear your patience. I'll be about a minute. But since this has been addressed only in reply by the Commission, I think in these circumstances we are entitled to the last word, and we can't have what happened before happen again. With respect to what my learned friend says about the operative terms of Annex 1, the direction is plainly akin to a court saying, you needn't address me on that, Mr Delamere, and then it goes on to decide the case on precisely the issue that you've been asked not to address on. And notice my learned friend doesn't suggest, contrary to what I submitted, that there was in fact no discussion at the hearing of the core passage of reasoning, paragraph 53 to 58. Of course, in our submissions, we addressed the objectives of the regulations by reference to the generic questions. If you look at the written submissions, they're peppered with references to the generic objectives of the regulations, including mutual trust, as to why they're compatible with the Section 66 judgment in general terms being admitted. And I'm afraid the finesse my learned friend seeks to put upon this very clear direction is not compatible either with what happened or with any sensible reading of it.
Well, that was definitely a minute, Mr Delamere. Excellent. Succinct. Good. Well, that brings the argument on the Brussels appeal to a close. And I'm not absolutely ruling out any subsequent reference to the Brussels appeal because these are consolidated for a good reason. But I discourage reopening of any of the issues in the Brussels appeal. Now, before we start with the arbitration appeals, can I just say that on Monday we will unfortunately not be able to start at 10:30 due to a commitment of one member of the court. We don't quite know yet, but perhaps you would remind me if I don't mention it again at the end of the day to tell you what time we will be starting. I hope it'll be not later than 11:30, but I can't be absolutely sure. That hour is going to be very difficult to give you back, and we suggest that you take it out of the human rights appeal, not out of the equitable compensation appeal. That's I think all we need to deal with now. So, I mean, we really do not think 2 days is needed for the human rights appeal, but no doubt you'll correct us if you think we're really seriously wrong. So it's Miss Stilnock, I think, over to you.
My lord, it is. bit of a change of subject. Just to orientate everybody, because everybody's going to have been using the CJU appeal bundles over the past couple of days.
You're going to have to speak up a bit, or I'm not going to be able to hear you.
Yeah, my lord, I apologise. In terms of the bundles we're going to be looking at, we're shifting into the arbitration appeal bundles, which means that I'll be referring to authorities bundle B. Electronic, that'll be absolutely fine, but I think they're different on the paper bundles. And my lady, I think they're...
Well, I've got the electronic bundles now, Miss Dilnott, so I'll try and follow you through those.
Okay, I'm grateful. And there's also a separate core bundle on this appeal, which I will refer to, not many documents, but the skeleton arguments, the judgments, the respondent's notices, appeal notices are in a separate core bundle. It's called...
I don't think I've seen it.
No, I've never seen it.
It's the same.
Oh, it is the same. Oh, forgive me, it's the same. It is actually the same core bundle as you've all been using. And I won't go really beyond that, other than one document, I think, in what's called the full supplementary bundle. Other than that, I'll confine myself to these ones. And I just, for the court's benefit, wish to just start on putting this appeal in terms of its scope in the overall context, because my Lord Justice Voss said right at the beginning of the opening day that the court was particularly interested in the interplay between equitable compensation and the regulation and the arbitration carve-out to the regulation, and what the effect of a grant of equitable compensation, which in this case is given to neutralise the effect of an incoming foreign judgment, would be. Now, I have to be completely straight with the court in terms of looking at the scope of permission to appeal, which...
Doesn't allow that.
My Lord, that's the issue. What I was going to show the court, to be straight with you, is to say France applied for permission to appeal before Mr Justice Butcher to run an argument that it was no function of equitable compensation to neutralise incoming foreign judgment which had been recognised as a matter of English law under the regulation. And we were refused permission to appeal on that ground. That said, the permission that we have been
Just
granted...
say that again. What were you refused?
Yes, to the High Court. I applied for... we applied before Mr Justice Butcher, firstly for an extension of time, for permission to appeal because we were out of time, and then permission to appeal for specific grounds of appeal. One was injunctive relief, one was equitable compensation. If you like, there was then a subset of equitable compensation, which was, the argument went, you shouldn't be granting equitable compensation, where the purpose and effect of an award of equitable compensation would be to neutralise the effect of a recognised judgment. That was the argument. And Mr Justice Butcher refused permission to appeal on the basis that he didn't consider the arbitrator's decision to be sufficiently open to doubt on that point. Yes, he refused the extension of time because the appeals were heard on a rolled-up basis.
Okay.
Had he thought it had merit, I would have had permission to appeal, but he didn't. So we are, to an extent, on this appeal, constrained by that refusal of permission. So I'm just going to take the court to the ground of appeal where we do have permission.
You're right in relation to France. Spain didn't apply for
My learning from Ms Hancock is correct. Spain didn't apply at all because this was not an argument that Spain had run before Sir Peter Gross.
No, they did run the argument, but they didn't appeal.
Okay, there we are. In any event, nobody has permission to appeal, I think it's fair to say, on this point. But the ground of appeal that we do have, I'm just going to take the court to it because I think it's important that everyone is clear what we are looking at. If I could ask the operator to go to the core bundle, please. Anyone operating on paper, it's tab 27. It's page 488. And this is France's single ground of appeal on equitable compensation.
488.
488, my lord, yes. Core bundle 488, tab 27 on the PDF.
So that's page 561 in the electronic.
Sorry, you're now moving to grounds of appeal to this court.
Yes, my lady.
But you were earlier, a moment ago, talking about appeal from the arbitrator. Am I right?
My lady, Yes, that's right. I'm now talking about the contours of the permission granted by Mr Justice Butcher to appeal to this court.
Okay, but the refusal of the extension of time, etc., was in relation to the appeal against
On
the
the arbitration.
arbitration decision.
My lady, yes.
Thank you.
So, my lord, you said to me the page number was 5. My page number on the electronic version is 488 on the core bundle.
Right. I mean, the electronic is 100 pages out. It's absolutely nightmare. I mean,
It's tab 27. My lord, you have tab 27. Is it at least
yeah,
tab
I've got
27?
it. I can find it. I'm quite good.
You are. There we are now. We're all
Doesn't matter what the numbers are. Eventually we'll get there. You know, just for future reference.
It does help if they
It's
match
helpful
up.
if the electronic numbers match the paper numbers. I know.
We don't need to give them to you. You're fine. Anyway, if I could just ask the court, it says paragraph 1 of the order of Mr Justice Butcher dated 21st of December 2023 should be set aside or varied because the judge erred in finding that the arbitral tribunal consisting of Dame Elizabeth Gloucester had the power to award equitable compensation for the French state's breach of an equitable obligation to arbitrate arising by application of the conditional benefit principle, or otherwise to grant it in the circumstances of this case. As a matter of law, equitable compensation is not available as a remedy for a breach of an equitable obligation to arbitrate, either generally or in a specific case of a third party asserting rights against an insurer pursuant to a direct action statute. And my submission, that is a broad ground of appeal, and it justifies the court looking at whether it is appropriate to grant equitable compensation in the circumstances of this case. And the circumstances of this case require my submission, following the court's indication on the opening day, that the court has to look at the contours and the limits of equitable compensation in this case and as applicable more generally in this context, including claims by direct action claimants who are found to be bound by arbitration clauses. What this court cannot do in my submission, where it is going to be potentially making statements of general principle, is not to consider the appropriate scope of equitable compensation which should be available in cases like these. So there has to be an element of specificity in terms of what is happening here. And the two measures of compensation, equitable compensation awarded by Dame Elizabeth Gloucester, were firstly damages in the form of the costs incurred by the club in participating in the Spanish proceedings when it decided to do so at the quantum stage, and secondly, granting equitable compensation in an equal and opposite amount to the amount of the Spanish judgment, the execution order as it's called in the second partial award. That award of equitable compensation itself was made on the basis, on the form of as an indemnity, because as matters stand, no loss, we said, had suffered by the club. So it's been done on a prospective basis. The only award of equitable compensation made on the current basis was an award that said that there was a present obligation on France in Spain to make payment in the amount of the Spanish judgment, because it was considered that there was already potentially an enforceable judgment coming out of the Spanish legal system. So those are the forms of equitable compensation which we're talking about in this case. And in this context, when one is looking to bind third parties to arbitration clauses and consider what the remedies available are, these are the types of compensation which are going to come up. This is the equitable compensation which is relevant. Damages for the costs incurred, fighting abroad, an amount to neutralise, if you like, operate as a set-off of the foreign judgment, and potentially in indemnity form, and also sometimes with fortification of the indemnity, which is what has happened on the common law side, the side of defence. And my Lady Justice Andrews said on Monday, I believe there are some cases about damages for breaches of arbitration clause. Absolutely right, and they're all in the bundle. What there aren't are cases about damages for breaches of equitable obligations. It's all on the common law side. And really the very question is it correct to import those common law principles and consequences into an equitable setup? So, my Lord, ladies, that's the scope of the appeal. And in my submission, it is going to be necessary, I think, for the court to consider the scope or type of equitable compensation which is going to be awarded in this case and more generally. Coming back, if you like, to the sort of non-regulation into sort of overlap part of the appeal. My learned friend, Mr Young, said a number of things about equitable compensation when he opened the case on Tuesday. And he gave the court, and I think it's fair to say, a reasonably sort of light sort of way, his argument on Lord Cairns's Act and the interplay. Well, the argument goes that equitable compensation isn't available because Lord Cairns's Act has come in and has occupied the territory other than for fiduciary or trust relationships. And Mr Young has said what he's going to say about that. That was really sort of Spain's part of the argument. And my understanding is, unless he wants to do so now, he's not going to say anything further on it, and I don't propose to do so. My starting point for the argument is somewhat different. It starts from the I suppose, the place that the court hasn't accepted that proposition, which means that as a matter of jurisdiction or principle, equitable compensation isn't set in stone. It is something which can develop in the appropriate case. So that is the working hypothesis. Although we say that doesn't answer the question as to whether it can or should be in this case. But I'm not going to be taking a position that equitable compensation is fixed for all time in the categories where there exist decisions.
Just for clarification, Ms Dilnott, to what extent are you adopting Mr Young's position in the light of what you just said? Because his position appears to be any award of equitable compensation outside the recognised categories is bad because it will drive a coach and horses through Lord Cairns's Act, I think is one way in which he put it. And certainly, if there's room for expansion, it's got to be in the fiduciary realm and not in a realm such as this. And I'm just interested in knowing what the position of France is on that.
Well, France adopts the argument which has been run.
Yes.
Spain ran the argument before Mr Justice Butcher, and we started our appeal before Mr Justice Butcher adopting it.
Yes.
But I didn't articulate it or advance it separately. It wasn't something France had conceived, but of course if anyone thought it was a good idea, we were perfectly happy to capitalise on it.
Yes.
But it wasn't the way I had put the case for France. And Mr.
Yes,
Young.
but if you're saying, as you apparently are, that equitable compensation is not set in stone and Lord Cairns' Act is not an absolute bar to future expansion of the remedy, you need to tell us what you say are the parameters of that expansion.
Well, my lord, yes. And I will endeavour to do that.
I mean, do you have some propositions that...
Yeah, I mean, my lord, I mean, logically, the first point has to be the court isn't able to do this, equitable compensation is confined. On the assumption or proposition that is wrong, one moves to the next logical proposition, it's not confined, but then one has to work out where it is going to go. And the core, really, of my submission will be that equitable compensation is not available as a remedy for an equitable obligation to arbitrate. If it is, in any shape or form, then it is not available in a case of a direct action claimant suing on a foreign direct action statute. And I will be drawing a distinction between other ways of asserting contractual rights, which result in people becoming bound by arbitration clauses, and direct action statutes, because there is now a fundamental distinction between these categories of claimants. And the court, if it's going to be awarding equitable compensation, it's going to be...
Hang on, just slow down a bit. So it's not available for bringing a claim under a direct action statute.
My lord, yes.
And then what did you say?
I think I said, I can't remember what I said, that the court... Exactly. I'm going to be saying that there's a fundamental distinction now between the position of assignees and subrogates and the position of claimants coming in the direct action route. The authorities to date have not accepted that distinction. They're focused on the right, which is engaged, which is the right to arbitrate, and it doesn't matter, they say, how you access that. But in my submission, when it's coming to these remedies, an ever more extreme form of remedies, it becomes important to consider what it is the court, well, the implications of what is going to be ordered against, and I'll show the court just the example of this case, the sheer number of direct action claimants that there are using foreign statutes allowing them to sue insurers directly, but also within criminal proceedings, taking advantage of the civilian approach to run criminal and tortious recovery and contractual recovery proceedings together. So what I was going to do in terms of just for the route map was to give a quick overview of the state's position, which I perhaps have already done, but then look at the Court of Appeal decision in the Prestige in 2015, so that the court can see, I know the court's already read it and I won't trespass on your patience, but I was going to look at characterisation and what was said about the resulting equitable obligation. That's it. Then I was going to look at passages from the principal authorities which deal with the question of what this equitable obligation is and remedy, and only those authorities, unless the court directs me otherwise, and then make submissions on what the resulting obligation is and whether equitable compensation should be available in relation to it.
All in 2 hours, now 1 hour and 40 minutes.
My lord, yes.
Okay?
Very good. Mr Hancock says I'm welcome to eat into his time a little bit, so it's very generous. We'll see how that goes. But, well, okay. Now, my Lord Justice Voss said right at the outset that you looked at all these myriad of authorities and they don't really help. And I would agree with that to an extent. There isn't an option but to look at some of these authorities to say what actually has been said by the Court of Appeal and the Supreme Court on the subject. But it's correct that whilst they explain to an extent the rationale and the workings of the conditional benefit principle, they are extremely light to non-existent on what the obligation is or the right is which arises and what the consequences are. The only decision which deals with that really is the Frio Dolphin, Sir Michael Burton's decision. But that doesn't contain any real analysis. It collects together everything that's ever been said on the subject. It's a perfectly legitimate way of doing it and says, I decide this, but it doesn't explore what the obligation is, and it doesn't really consider the implications of granting.
And it's important to ask the question, when does this obligation arise?
Well, yes. That's right. That question is, for present purposes, answered by the Supreme Court in the Atlantic Confidence.
Sorry?
It's answered, at least to an extent, by the Supreme Court in the Atlantic Confidence, which says that whilst a third party to an arbitration clause sits and does nothing, does not assert its rights, does not create a dispute, then they're not bound. You cannot force them to litigate in this or arbitrate. They're simply not bound. But as soon as a right is asserted such that a dispute arises, then there is an obligation to arbitrate that dispute. It is from that point in time that they are bound. So importing that into our case, it may be that the states became bound at the moment they filed accusation pleadings in the Spanish proceedings. Had there been a letter before action or some such?
Hasn't that been decided by the Court of Appeal in these proceedings?
My lady, well, yes, when the analysis of Lord Justice Moore-Bick was
Exactly.
when they commenced those proceedings, that's when the obligation arises, which fits with the analysis of the Supreme Court in the Atlantic.
Of course.
Yeah, yeah.
But I'm just making the point it's actually been determined. In
My
these
lady,
proceedings.
it has. Then the oddity, well, it's not the oddity, a central point about that is it said, yes, they're bound, but equally in so doing that, it's not a breach of the arbitration agreement. So you're bound, but you don't breach the arbitration agreement by commencing the Spanish proceedings. And I'm going to take my lady to that passage, because this is part of the difficulty with where we find ourselves in the conditional benefit principle. Because the courts are saying you are bound, the right itself is conditioned, as soon as you assert the right you become bound. But they're equally at pains to say you're not a party, it's not an actionable breach, there isn't breach of contract. And you may say, well, that's fine because it's all in equity, but in my submission that analysis just isn't going to
What does that mean? I mean, I didn't understand how you can be bound and then you do something inconsistent with the obligation and you're not in breach and it's not actionable.
Well,
I mean, you'll have to show. You better show us.
I'm going to have to show you. I'm going to have to show you how the obligation is described. And my submission is going to be, it's not described in a way which, if you like, creates a cause of action, which the beneficiary or the party to the arbitration agreement can take and run with and get damages from. It's not a cause of action in that sense. Because that's what, if you're going to be awarding equitable compensation in my submission, that's really what you need. You need a substantive obligation, breach of which gives you a cause of action. Cause of action sounds in damages. Yes. And part of the issue with the entire conceptual underpinning of this line of authorities is that the courts have decided the third party is not a contracting party. Contract, therefore, doesn't have a role to play. It arises entirely in equity. But the way the decisions have gone indicate that simply what arises is an obligation entirely equivalent to contract. And if you then breach that obligation, there's an obligation to pay equitable compensation, exactly the same as contractual damages. There is absolutely, if this line of logic follows through, no difference between saying someone is a party to an arbitration agreement and being a third party bound in equity. It's just the same thing. It's a complete assimilation of contract and equity.
You're going to tell us why that's an undesirable state of affairs.
My lady, I shall. I was going to do it in the third part of my statement. I'll be talking quite heavily. Well, I'll say that's not what's happening. And actually, the authorities consciously don't do that. If we look at the
If
J.
you're wrong about that, you're going to say it's not a good idea.
Exactly. But I'm going to try for the first bit first. So if I could ask, with that sort of introductions, I should just also say to the court in terms of just a very quick potted history of how the authorities go through chronologically in terms of the relief which is developed. One has the enduring statement of principle from the J. Bowler in 1997, which is Lord Justice Hobhouse, which I'll take the court to, which is where you get an anti-suit injunction granted on the basis of the conditional benefit principle. There was then through transport number 1 in 2005, Court of Appeal, and they declined to grant an anti-suit injunction, partly because the third party wasn't a party to the arbitration agreement. And they declined to grant a declaration saying the third party was in breach of contract because it wasn't a party to the arbitration agreement. Through transport number 1 has not been followed in relation to anti-suit injunctions because the J. Bowler was not cited to the court. It was then in through transport number 2 that it was Mr Justice Morbick at that stage then explained how it was that a third party becomes bound to arbitrate under the mechanisms of the Arbitration Act, section 82, when they became bound to arbitrate. There was then the case of, in this court, the Yusuf Sepnionlu, I can never pronounce it, in 2016, which was a direct action case. An anti-suit injunction was granted, and the Court of Appeal decided to follow the J. Bowler in preference to through transport number 1, acknowledging that J. Bowler hadn't been cited in through transport number 1. It's also fair to say that in that case, the court decided not to draw any distinction between direct access cases or direct action cases and assignment and subrogation cases, with Lord Justice Morbick saying he preferred to concentrate on the right, which is the issue, rather than the means of access. I say that to take it on the chin in terms of what I have to persuade the court that there's a difference in this case. One then comes to Airbus in 2019, where the Court of Appeal granted for the first time declaratory relief as to the position in relation to breach of an equitable obligation to arbitrate. And it's really the analysis of the equitable obligation in Airbus, which is the springboard for the grant of equitable compensation by Sir Michael Burton, the arbitrators and the judge in this case. Because in Airbus, Lord Justice Mayall said the obligation is equivalent to contract. And it is that statement which has really led to the grant of equitable compensation in my submission in the recent cases. And then finally in 2021 there was the case of the Atlantic Confidence before the Supreme Court, which endorsed Lord Justice Hobhouse's statement of the principle of the conditional benefit principle in the J. Bowler. And that's why I say that really that statement, and we'll look at it, of Lord Justice Hobhouse is at the moment the definitive statement of the conditional benefit principle, and that's been endorsed by the Supreme Court. And the very final case of relevance is the Frio Dolphin in 2021, which the court will be familiar with. So, if it pleases the court, I would be grateful if we could look at the Court of Appeal's decision in this case in 2015. I've been looking at it in Authorities Bundle B. I don't know if the court has been looking at it in the CJAU appeal, but if I could ask, if you go to stay in Authorities Bundle B, it's tab 36, page 667. I'm grateful. And I just wanted to look at what the court said about characterisation, partly because of the comments my Lord Justice Voss made on the first morning that the Court of Appeal considered the relevant obligation to be contractual. I just wanted to be clear that what was decided in this case was that the issue in dispute between the parties was characterised as contractual for the purposes of ascertaining the governing law. The obligation arising on the part of the states to arbitrate was not said to be contractual and was not equated to being contractual. But if I could perhaps ask if we could start at paragraph 11, which is on page 670 of the electronic copy. This is where Lord Justice Warbeck explains the characterisation exercise. And if I could just ask the court to read from 11 down to the first paragraph of 14 before one gets into the quote from Through Transport. Yeah, I'm not at that point yet.
Beginning of 14, you said?
My Lord, yes, just from the words as in through transport.
Yeah.
And then where he decides that it's a contractual analysis. The issue is one to enforce a contractual term as opposed to an independent statutory right. And it's that the characterisation exercise operates in these cases as a gateway. It decides the governing law. Because of characterisation, one looks at how what the statute is and what's being applied for under the statute. If it's deemed to be a contractual, an application to enforce a contractual right, English law applies. And that's what gets us into the conditional benefit line of cases. Were it characterised otherwise, we would not be under a conditional benefit analysis. But is that characterisation exercise that is sucking in all these claims by third parties, for example, on direct action statutes. If then I could just ask the court to go to paragraph 24 on page 673. And I'll just take the court to what we say the relevant passages. He says, as the judge pointed out in paragraph 87, whenever legislation gives a third party a right to make a direct claim against an insurer by reference to the terms of the contract of insurance, both the statutory and contractual rights are involved. The third party would have no right to claim against the insurer but for the right given him by statute, but the content of that right is defined largely, if not entirely, by contract. So that's essentially how one gets to the contractual reasoning. And then he says at 25 over the page, in my view, the critical question is what, in substance, was the nature of the right that the legislation was seeking to confer on the party. And then at the bottom of 25 and the beginning of 26, he indicates what might be relevant in a case falling one side of the line or the other. but the key finding is paragraph 30, going over the page, right at the bottom. Lord Justice Morbick says, "For these reasons, I have reached a conclusion that the issues relating to the appellant's right to seek compensation from the club are to be characterised as issues relating to an obligation standing in contract, and that as they are to be determined in accordance with English law as the proper law of the obligation." So that's the characterisation exercise. He then goes on to consider what is the result of that and what is required from the third party seeking, as the court has analysed it, to enforce the contract. And the court had to consider specifically the question of whether the requirement in section 9 subsection 1 of the State Immunity Act for an agreement in writing to arbitrate, which brings within as an exception to immunity, whether that can be satisfied by anything other than a document signed on behalf of the state. Because, of course, here the states hadn't signed any form of arbitration agreement, written consent, and so the question was were they immune or not. And in that context, the court went on to consider how a non-party becomes bound by an arbitration agreement. At paragraph 68, just for the court's note, I don't think we need to turn it up specifically, the Lord Justice addresses the reasonings and findings in through transport number 2, and then at paragraph 69, which is, let's find it, on page 680, this is probably the critical finding for present purposes. Although in the present case the appellants must also pursue their claims by arbitration, they, like the claimant and through transport, are not parties to the arbitration agreement in the full sense. If they wish to pursue their claims, they must do so in arbitration, but commencing proceedings in Spain did not involve a breach of an agreement to arbitrate. When the appellants began proceedings against a club in Spain and the club failed to concede the claim, disputes arose between themselves and the club, which were capable of being referred to arbitration and can only be validly be determined in arbitration. So that's why my Lady Justice Falk is entirely right. When the proceedings are started in Spain, in this case, that is the moment where they say that the states became bound to arbitrate.
So it's said there's no breach of a contract, but that's not tantamount to a finding that there's not breach of a duty to arbitrate.
My lady, no, it's not. But what one sees in the authorities again and again is drawing a distinction with, if you like, eschewing the proposition that there is not only in sort of a breach of an agreement to contract to arbitrate, but something which gives rise to a cause of action, something which is actionable in the sense that one would understand it, which sounds in damages. The statements of principle and the authorities talk about a constraint. It operates by way of constraint, hence the remedy of injunction. But in my submission, the reason why they keep on saying it's not a breach, it's not equivalent to a cause of action for damages, because the authorities, the courts do not see whatever obligation it is which arises as being of that quality, of being of that nature. Because otherwise, there's simply...
Are you saying not that the obligation is not such that it's capable of being breached?
It's not capable of... it's capable of being breached, being contravened. I can't argue that if you're obliged to arbitrate and you don't, that's you've not complied with your obligation to arbitrate. What I do say is that given the nature of the obligation, does not result in an obligation to pay damages, i.e. a secondary obligation arising to do that.
I can see how sitting on your hands and doing nothing about it wouldn't actually be capable of being characterised as a breach of anything, because there's no positive duty to arbitrate unless you want the dispute resolved. But at the moment I'm struggling with the idea that conceptually, if you go off and litigate the dispute that you're bound to arbitrate in a different jurisdiction, that would be something which is capable of sounding as a breach, regardless of whether damages are that's a separate issue, but characterised as a breach of the equitable duty.
Yeah, I don't think I'm saying that. I'm sorry, Mr. Hancock is saying there's already a finding from the arbitrator in terms of declaratory relief, in terms that France has breached the obligation to arbitrate. I hope I was clear in my answer that I'm not arguing that there's not, that France has adhered to the obligation declared to exist. What I am addressing is what that obligation is, as a juridical nature of it, and what are the consequences of that, therefore. Because you have to work out what it is before you can decide what the consequences of it are. And I'll go to the J. Bowler next, which is the clearest exposition of the position, where you have Lord Justice Hobhouse trying to explain almost, it doesn't really say unfortunately what it is, but what it isn't. And it's what it isn't, in my submission, which is significant and has some significance for whether the court is going to impose really an equivalent of contractual damages for contracts on third parties.
Let's look at J. Bowler.
Let's have a look at the J. Bowler. It's tab 23, authority number B, page 446. Does the court have that?
Yeah.
The facts were somewhat complex, but for present purposes, I think all that the court has to be aware of was that the vessel was subchartered pursuant to a voyage charter entered into between time charterers and a voyage charter to transport cargo of steel from Brazil to Bangkok. And the bills of lading in relation to the steel were issued in Brazil, and then subsequently bills were issued in Hamburg. Vessel caught fire, voyage was abandoned. Insurers of the voyage charters paid out the cargo interests and in effect became subrogated to those interests. The owners commenced a limitation action in the Admiralty Court. The insurers of the voyage charter then commenced their own proceedings in Brazil on the basis of the Brazil bills of lading. The time charter was a party to the arbitration agreement, then commenced an arbitration against the voyage charter and the insurers, in which the time charter maintained that the proceeding in Brazil was a breach of the arbitration clause to which it claimed damages, and it also claimed an anti-suit injunction. The voyage charter and insurers defended the position on the basis that the insurers were not a party to the contract and were entitled to proceed in Brazil. At first instance, Mr. Justice Morrison granted leave to serve out, granted an anti-suit injunction, and that injunction was maintained. When it went to the Court of Appeal, I think the leading judgment was given by Lord Justice Hobhouse, with a subsidiary judgment by Lord Justice Scott. And if we could start with, I think it's page 284 of the report, page 451 of the bundle. Where Lord Justice Hobhouse analyses the nature of the rights being asserted by the insurer. He says, it's clear in my judgment, this is at the beginning of the final paragraph of the sidelining on that page. It is clear in my judgment that the rights being asserted in the Brazilian action by the insurance company are rights derived from and dependent upon the rights of the voyage charterers. The argument in this court of Ms Bucknell QC, who appeared for the insurance company, that the rights being asserted in the Brazilian action were those of the tie receivers cannot be accepted. The plaintiffs are correct that the claims are claims which, if made by the voyage charterers, are claims which the voyage charterers were obliged to refer to arbitration in London under the arbitration clause in the voyage charter party, which, as accepted by both sides, is in English law the governing contract as between the voyage charterers and the time charterers. And if one then just goes on to page 286 of the report, page 453 of the bundle, in the preceding paragraph, Lord Justice Hobhouse refers to I think authorities which will be familiar to this court, the Padre Island No. 2 and the Jordan Nikolaev, and then he states on page 286, the sidelining, these authorities confirm that the rights which the insurance company has acquired are rights which are subject to the arbitration clause. The insurance company has the right to refer the claim to arbitration, obtain if it can an award in its favour from the arbitrators, and enforce the obligation of the time charterers to pay that award. Likewise, the insurance company is not entitled to assert its claim inconsistently with the terms of the contract. One of the terms of the contract is that in the event of dispute, the claim is to be referred to arbitration, the insurance company is not entitled to enforce its right without also recognising the obligation to arbitrate. And that is the key passage which has been endorsed by the Supreme Court in the Atlantic Confidence. Lord Justice Hobhouse then goes on to describe an argument which was put by insurers that he couldn't do this, he couldn't grant an anti-suit injunction because insurers weren't a party to the contract, and therefore the burden doesn't transfer because there was no innovation and there was no cause of action arising. And he says, Mr. Bucknell submits that even so, there is no right which can be asserted by the time charterers against the insurance company which gives a cause of action by the former against the latter. She submitted that to recognise any such cause of action would amount to treating the burden of the contract as having been transferred, something which would only occur if there had been innovation. In the present case, all that had been transferred was the right of the voyage charterers against the time charterers. The burden of the insurance contract was not transferred. And then he says, the insurance company, forgive me, the insurance company came under no actionable liability to the time charterers. In my judgment, this argument fails to understand the nature of the equitable remedy which is being sought in this case. And he goes on to give an explanation. And then he says what it says at the bottom of the page is, the injunction was granted to provide the debtor with an appropriate protection for the unconscionable conduct of the assignee. It does not depend upon any liability of the assignee for the sums to be set off. The right to apply for an injunction is not a cause of action, the same character as the right to sue for damages for breach of contract or tort, or to collect a legal debt. It is an application for an equitable remedy to protect the plaintiff against the consequences of unconscionable conduct. And then right at the end he says, the insurance company is failing to recognise the equitable rights of the time charterers. The equitable remedy for such an infringement is the grant of an injunction. And in my submission, in fairness, he is addressing the relief which is being sought, which is an anti-suit injunction, and not anything else. But he is at pains in his analysis to explain that the way the conditional benefit principle operates is not to, or what does not arise, is a cause of action of the same character as the right to sue for damages for breach of contract or tort, or to collect a legal debt. That is in effect what he is saying. It operates as a constraint to avoid inconsistency, hence the grant of an injunction. But he is plainly having in mind that there are limits to this, and it does not operate.
But is this bit approved in the Atlantic Confidence?
My Lord, this was not the specific, the passage which I referred to earlier about inconsistency.
Yes.
That definitely was the bit which was approved by the Supreme Court. The Supreme Court did not address.
Well, we're going to look at that, I guess.
Well, my Lord, we are. But in my submission, this passage forms a piece. This is his reasoning. This is his description of what the conditional benefit principle is.
Yes, but
and how
time's
it operates.
moved on. I mean, this is all very well, but we're 1997. I remember vividly those days.
Well, my Lord, yes. But times haven't moved on in my submission in terms of what the principle is and what rights and obligations arise.
You probably didn't appear in the House of Lords in front of Lord Hobhouse and Lord Millet and watch the difference between them when equity was being discussed.
Well,
which I think is quite interesting here, because one can sort of see the yeah.
Yes, that's
So,
right.
so we do need to look at the really modern authorities, it seems to me.
My Lord, we absolutely, well, the next, if you like, or the only then modern, or, well, there's two. There's Airbus. What I'll say about that is it says no more.
Sorry.
Airbus in 2019,
Airbus, yes.
so that really is modern authority.
Yes.
But I'm going to be saying that Lord Justice Mail said didn't dissent from this analysis at all. He summarised it. He hasn't dissented from it at all.
Okay.
And so the point remains, and neither did the Supreme Court. So my submission is, whatever one thinks about equity moving and all the rest of it, what the nature of the right or obligation is set out authoritatively in this judgment, and that has not changed.
It seems like a right to an injunction in equity.
Pardon, my Lord?
That's what he's saying, is it's the right to an injunction in equity.
Yes, that's right.
He's not actually addressing this point at all. That's the problem.
He's not direct, but my submission is he's drawing a distinction between this type of case, a conditional benefit case, and a contract case, such that it is simply not permissible to ally the two and go, right, bound in equity, all contractual principles apply, contractual remedies apply. That's precisely what he's not doing. Because otherwise you'd simply say, this operates in the same way as the contractual obligation as which a party to an arbitration agreement has.
He wouldn't have said that in 1997. But let's see what they said later.
My lord, in which case, let's look at Airbus, which we can take quite quickly. It's same authorities bundle, tab 43, page 842. And the facts, very briefly, are Airbus sold aircraft to an Italian company. The contract concluded an ICC arbitration clause. The relevant parties then into a separate warranties agreement, which contained an exclusive jurisdiction clause in favour of the English courts. And when damage was caused to the aircraft, Italian insurers indemnified the operator of the aircraft and then exercised their rights of subrogation granted by Italian law and commenced proceedings in Italy. Airbus commenced proceedings in the commercial court seeking a declaration of non-liability and a declaration that insurers were in breach of the exclusive jurisdiction clause by commencing proceedings in Italy. And that's the novelty of this decision. This was the first time that a declaration was sought in relation to, if you like, a non-contractual case. Insurers then challenged jurisdiction and argued that they could not be in breach of an exclusive jurisdiction clause to which they as insurers were never a party. And the relevant issue, but before the Court of Appeal, there were three issues, but only one is relevant. And it starts at page 866 of the report. But the question was whether the court could make a declaration against the appellants that the commencement and pursuit of the Italian proceedings was contrary to the terms of the exclusive jurisdiction clause in the warranties agreement.
Sorry, you've lost me. Where are you looking now?
My lord, it's page 866.
Of what?
Of the report.
Of the report?
Yes, of Airbus. My lord.
I know, but is it in the bundle number?
Oh, sorry, the bundle, the pagination, the electronic pagination.
866.
Yes.
Oh, paper pagination.
Paragraph 85.
It's also the electronic pagination. Paragraph 85.
Yeah, okay, 85 is good. Thank you.
Okay.
Yeah.
I think the electronic pagination is out of kilter, at least mine is.
Yes, miles.
Yes. I mean, if I type 866 into my PDF, that is what comes up.
No, well, we get
But
877.
you don't get that.
We're miles away.
I know, I'm so sorry. I'm so sorry.
Not only are we miles away, it's not consistent through the document.
No.
Don't worry, on you go. Final issue.
It's a special result. Anyway, 85 encapsulates the issue relevant for our purposes, which was before the court. One sees at 90, going over the page, please, operator, and if I can ask the court actually just to read 90 to 92, which deals with the J Bowler, then if I could also ask the court to read on to 93, which is Mr Justice Coleman's judgment in West Tankers, which is interesting.
So where are we ending? I've read 95.
Mine great from 95 is sort of part of the key reasoning. Yeah, I'm coming on to 96. Okay.
But, I mean, he seems to be saying, well, you can go as far as a declaration.
Well, my lord, that's fine, and that's as far as he does go. But if I could ask the court then to go on to 96, this is where we start to. This passage really, in my submission, is the springboard for the grant of equitable compensation, which has happened. He says, in my judgment, the House of Lords implicitly approved the reasoning of Coleman J on this point, but in any event, I would do so now. That's the reasoning in West Tankers. Accordingly, the position is as follows. Insurers exercising rights of subrogation to make a non-contractual claim are bound by an English arbitration or jurisdiction clause to the same extent as the insured would have been, whereas the commencement and pursuit of proceedings contrary to the terms of an arbitration or jurisdiction clause by the insured would constitute a breach of contract. The commencement and pursuit of such proceedings by insurers constitutes a breach not of contract, but of an equivalent equitable obligation which the English court will protect. And it is that statement that it's an equivalent equitable obligation which has resulted in the reasoning that the equitable obligation is simply parallel, the same as the contractual obligation, and therefore the same remedies must be available for breach of this equitable obligation as the contractual obligation. But that statement in my submission in terms of what this obligation is merely shorthand for what has been said by Lord Justice Hobhouse and subsequently Mr Justice Coleman about the nature of the obligation which arises. And both those judges talk of there being no actionable breach of an obligation to arbitrate.
Well,
and of course, it said straight back to me, well, that's the contract. We're talking about equity.
He does say, I mean, he does say it constitutes a breach, not of the contract, but of an equivalent equitable obligation which the English court will protect. And the remedies include a declaration. So he's leaving open what else?
He is. He's decided declaration, but he hasn't decided anything else. That is the limit of this authority.
Yeah.
It does not give the court any assistance on equitable compensation as such. But why it is so relevant is because really it has been the sort of linchpin of the reasoning to date of the arbitrators and the judge as to why it's okay to grant damages.
Yes, but the problem is we're bound by this. Right?
Well, yes. But
this is ratio of the Court of Appeal. So we can't depart from this even if we wanted to.
No, my lord, no.
So
I'm not.
There is a finding, a holding of the Court of Appeal that in these circumstances there is an equitable obligation binding the non-party, which the English court will protect, and for which a declaration and an injunction lie. Obviously not against a sovereign state.
Yes, my lord, yes, but that description is simply predicated on J. Bola.
Whether it's predicated doesn't matter because he says the House of Lords has said it and he's saying it.
Well, my lord, yes. But then
also, it could be said that what he's doing is formulating the basis on which injunctive relief would be granted, because there's got to be some kind of wrong for which the equitable injunction is a remedy. You don't just get an injunction in a vacuum.
No, but that's what Lord Justice Hobhouse had already analysed in
Yes.
J. Bola. He said the wrong is acting inconsistently with the the arbitration agreement.
I mean, I hate to disagree with my lady, but the problem with saying you don't just get an injunction in a vacuum is the rationale of the Supreme Court in Persons Unknown, which does say you can get injunctions for all sorts of things and doesn't place it on the basis necessarily of a legal right by A against B, because that was dealing with contra mundum injunctions.
Yes.
But I mean, I don't want to divert you. Am I right in thinking that this authority binds us to decide that in this case there was an obligation on Spain to arbitrate, and that was an equitable obligation which the English court will protect and could have granted an injunction and a declaration, injunction if it had not been a state, and a declaration anyway as to those rights?
My lord, yes.
Yes. And now we have to look whether the equitable obligation, which undoubtedly exists as a matter of law binding on us, can sound in some kind of compensation.
Yes. Well, there are two elements. There's the equivalent to contract, because in my submission, that statement has to be understood in the context of the J. Bowler explanation, which has been endorsed by the Supreme Court in Aspin. So it doesn't say quite the same thing as Lord Justice Mayles, and that is also binding.
Sorry, where's that?
In the next case, the Atlantic Confidence.
Let's go to the Atlantic Confidence.
Well, that's in tab 48 of the bundle, page 1072 of the bundle, or my bundle.
Yes.
Everybody has that. In this case, this was a case where the insurers had entered into a settlement agreement pursuant to the loss of the vessel, and a payment was made out under a hull and machinery risks policy at the direction of the bank, which was the appellant in this case, who was the assignee and loss payee under the policy. Policy contained an exclusive jurisdiction clause in favour of the English courts. Following the discovery that the owners and managers had procured the scuttling of the vessel, insurers tried to get their money back and tried to get it back from the bank. And so they sued in the commercial court, and the bank challenged jurisdiction, saying it was not a party to the insurance policy, and importantly, it had not taken any steps in relation to the insurance policy. So I accept there is a key difference between this case, the facts, and my case, which is here the bank had done nothing and not asserted any rights, hence it was found not to be bound by the conditional benefit principle, and our case where steps have been taken in relation to the insurance contract. The importance of the decision from my perspective is what the Supreme Court says about the workings of the conditional benefit principle, and that they endorse the formulation of Lord Justice Hobhouse. So if we ask the court to go to paragraph 27, please, page 1108 of the bundle.
Is that 7? How many judgments?
7. Forgive me, Miss Hart says it's 1122 of the PDF. No, no, it's not.
Paragraph 27 is 1108.
It's I'm right. It's 1108 of the PDF.
1119 on mine.
I'm so sorry. It's paragraph 27 of the judgment. There's quite an extensive report of the argument in this case, which takes a bit of getting through. If I could ask the court to read paragraphs 26 on page 1107 and 28, where you will see the precise formulation which was approved, the excerpt from the judgment of Lord Justice Hobhouse in the J. Bowler.
26 and 28.
26, 27, and I don't need 28, but actually, if it read 27 to 29, then that's the whole thing.
All goes back to Tito and Waddell. Mm-hmm. Marvellous. Ocean Island.
Well, it's all familiar.
Where do we finish?
End of 29, my lord.
Hmm?
End of 29, please, my lord.
End of 29. This, as you say, is quite a different position.
My lord, yes.
I mean, this doesn't really deal with the juridical foundation of the right.
No. No. None of them do, and Airbus doesn't either. There is no elucidation of the juridical foundation of the right, or the obligation, or really what it is. It's the statement that keeps coming up again and again is the obligation not to act inconsistently. And the emphasis here is on the constraint. It operates by way of constraint. And that is the reason why, in my submission, anti-suit injunction is usually the appropriate remedy.
And from here we go to Mr. Justice Burton, do we?
Well, my lord, I wasn't going to show you Mr. Justice Burton because there's no real
there's
analysis.
There's no analysis.
There's no analysis.
Juridical
It's just
basis there.
literally everything is just set out that there's ever been, and says this is this is what I'm going to do. So it doesn't really advance matters, save that it's a decision where the judge has decided to grant equitable compensation.
And yet, Mr. Justice Butcher said, I wouldn't depart from him and I wouldn't depart from Sir Peter Gross. But Sir Peter Gross also gives no foundation, except he cites Lord Justice David Richards.
Yes, that's in Auden.
Yes.
Auden and Mackenzie.
He cites Auden and says
Yes, well, in that part of the
the categories are not closed.
yes, obviously, well, that's right. He was dealing with the argument put by my learned friend that the categories are closed because equitable compensation deals with fiduciaries and trustees. And Lord Cairns Act does the rest, and if there's a gap, there's a gap. That's the statutory scheme, and that's Parliament's intention. That's what Sir Peter Gross was dealing with, but he doesn't himself give any further elucidation of the nature of the principle. These authorities are all that we have in terms of trying to understand what the principle is, how it works, and what the rights and obligations are which are arising out of it, and which will shed some light, therefore, on the appropriate consequences
I mean,
and
are they
remedies which
really
are available.
all we have? I mean, and I haven't done the research, but I remember a very active debate in the late 90s about Target and Red Ferns, where the nature of equitable compensation was actively debated and written about, and I even wrote an article myself about it. And it was all, I think, based on Lord Justice Millett's judgment in Mothew, and then in Target and Red Ferns. Now, have you looked at all that?
My lord, yes,
you
AIB
get
and
nothing
Red
out
Fern
of any
and
of
Target
that.
and Red Ferns, it doesn't answer the point. They deal with equitable compensation, what it is, if you like.
And what is it, according to those authorities?
Well, if we look at, well, the most recent statement is probably Lord Justice Richards in Auden and Mackenzie. We can turn it up in terms of, he says it's a personal remedy for breach of fiduciary obligations and trustees.
But I thought Lord Millet in Mothew wagged his finger at all those common lawyers and said they didn't understand what equitable compensation was, and it was all to do with taking an account in chancery, and when an account was taken, you surcharged and falsified the account. I mean, I'm thinking.
No, I mean that's the old school, very narrow view of what equitable compensation was, what its original purpose was.
Right, but somebody must have taken a leap from those days of the late 90s. I mean, Mothew is a very authoritative case, right?
It is.
Does it mention any of this, the juridical basis for equitable compensation? I thought it did.
Well, for equitable compensation, yes, but not for the right which arises here. Equitable compensation, there's plenty of writing on equitable compensation when it's been granted to date. Not in anything like this. There's nothing like this out there.
I mean,
it won't help.
What he was explaining in all those cases, I thought, was that everybody misunderstood that there was a species of something called equitable compensation that you could just get out when you didn't have anything else in your quiver.
Yes.
And I mean, if that is right, and David Richards, Lord Justice, says what he said, I mean, where does a general right to equitable compensation come from? Does it
my lord,
what
there
do you
isn't.
say? I mean, does it come from only from a right to grant an injunction? I mean, that's quite that's quite established. Does it come from a right to grant specific performance, a right to any other equitable remedies? I mean, what? Surely Spry or somebody like that, or Fry, surely they've got something about it, haven't they?
Well, my lord, Spry, I mean, we go to it. Spry is cited in the recent Wolverhampton decision of the Supreme Court in terms of equitable obligations and how they develop. But what is not said is when, if you like, or an answer of when it will be available in new circumstances. So equitable compensation to date granted in trusts, surcharging accounts, fiduciaries, directors, breach of those duties. It's been granted for dishonest assistance in breach of trust, again related to a trust, for knowing receipt of property.
But why, if you've got an
proprietary estoppel?
So why, if you've got an equitable obligation, according to the Court of Appeal, should you not get compensation for breach of it? I mean, what I'm finding difficult at the moment, I mean, I'm coming to this quite fresh, actually. I haven't done a case like this for years. It seems, if the Court of Appeal has said, whether I agree or disagree, it really doesn't matter, that there is an equitable obligation for which you can get a declaration and an injunction, why should you not, in some circumstances, get damages or equitable compensation? And surely the only thing to discuss is what are those circumstances?
Well, my lord, in my submission, the nature, if you like, of the obligation and what it is what has been addressed by Lord Justice Hobhouse and then as endorsed by the Supreme Court, the obligation to avoid inconsistency. And in my submission, the analysis in the J. Bowler and the subsequent cases which say that this is not breach of contract, it doesn't produce an actionable breach, it's not a cause of action, indicates that the courts are not seeing whatever this is, this obligation, as, if you like, a freestanding cause of action, which is what we're talking about, which sounds in, call it contractual damages, call it
Are you going to show us
compensation.
persons unknown in the Supreme Court and what they said about the nature of the of equitable
My lord,
obligation?
I can. It's
Well, I
quite a different...
would like to see it, actually.
Okay.
I mean, obviously I've read it, but could we just see it briefly?
Yes, my lord.
Where
It's
is it?
tab 57, page 1466 of the bundle. Wolverhampton. I'm just...
And what's the best bit, as it were?
My lord, I'm just looking for the quote from Spry, which was endorsed by the court.
Is 17?
The Spry quote.
It starts from paragraph 16, my lord, and then goes on from there.
Yeah.
It's that entire sidelined section. Find Spry. My lord.
So he says at 17, they say, the power to grant injunctions is unlimited. Right?
Yes.
See, broad idea. The breadth of the power, blah.
But it must be, that's why you have to take care with this, because it's talking about injunctions and the power under section 37, which of course simply codifies the court's inherent jurisdiction which of equity which existed before.
Right.
But it's the court has an unlimited power, limited subsequently only by judicial self-restraint, which means the court has power to develop additional remedies, new forms of injunction. It says nothing about the court's general ability to develop new equitable remedies or to impose equitable compensation for new relationships or obligations. Which is why I thought the passage from Spry may be probably the most relevant, which is at paragraph 147, which is at page 1513, of the electronic bundle.
I'm grateful. I was just rising, in case it's helpful, to refer your lordships to to paragraphs 145 to 153, which is where the Supreme Court deals with the SPRI quotation and general considerations.
What SPRI says, and this is sort of the key to the court's reasoning in this case, the powers of the court with equitable jurisdiction to grant injunctions are, subject to any relevant statutory restrictions, unlimited. Injunctions are granted only when to do so accords with equitable principles, but this restriction involves not a defect of powers, but an adoption of doctrines and practices that change in their application from time to time. So this is really facing the submission that the court didn't have power to do what it was doing. The court says, yes, we do have power, and injunctive relief is an equitable remedy which can develop over time.
There's a whole sort of exegesis about the Moreover injunction and how that developed to, you know, the general principle is that injunctions may be issued in new circumstances when the principles underlying the existing law so require. That's what's said in paragraph 22.
Yeah, my lady, yes.
But
which is also why I didn't think Wolverhampton was directly on point, because it doesn't really help us with analysing what the right or obligation is in this case, and therefore what the consequences are. I've accepted the premise that equitable compensation isn't set in stone for all time, but it doesn't help you work out whether and why it should be granted for the particular form of obligation arising here. Hasn't been in the past.
Well, I mean, if you look at paragraph 149, after the reference to broad idea, it says the basic general principle by reference to which equity provides a discretionary remedy is that it intervenes to put right defects or inadequacies in the common law. And that's frequently because equity perceives that the strict pursuit of a common law right would be contrary to conscience. And that underlies, for example, rectification, undue influence, and equitable estoppel. That conscience-based aspect of the principle has no persuasive application in the present context. And then, protection of rights, the equitable remedy of specific performance. I mean, all this seems to me to be quite indicative of the attitude of the Supreme Court to the application of equitable rights. I mean, this is the passage I was thinking of, actually, and it goes right on. I haven't got time to read it now, but...
yes, well, the development of equity is also part of the Supreme
But I mean,
Court.
it says the third, this is at 152, the third general equitable principle is equity's essential flexibility. Not only is an injunction always discretionary, lengthy and painstaking development of the atom pillar. There is no supposed limiting rule or principle apart from justice and convenience, which equity is regarded as sacrosanct over time.
Well, yes, my lord, but that is specifically in the context of injunctive relief, and the court's
Well,
specific
it's
powers.
really not. That's the point, and that's what I'm putting to you. You know, I sort of feel all this quite strongly because I dissented, as you may know, in broad idea.
My lord, yes.
So I said that it was not appropriate for the Privy Council to write when injunctions could be granted on a plain sheet of paper when there's 50 years of authority. Right? The four of them disagreed with me. That was enough. The President and Vice President agreed with me. Now, since then, we have this case, which takes that case even further and seems to me to inform the question of what equity is for. And I think you have to persuade me anyway that when he says at 145 that he's going back to first principles, and then at 147 approves SPRI saying there's a recognition of the great width of equitable powers, historical blah blah blah, and then 149 equity provides the discretion, it intervenes to put right defects in the common law, that is not indicative of a view in the Supreme Court now, which certainly was not the prevailing view in 1997, that there are no bounds, and that if you have an equitable obligation, of course you would grant equitable compensation if you needed to do justice. I mean, what do you say about that?
My lord, I say that the authorities, if you like, have delimited, not necessarily very clearly, what the right and obligation is in this case. They have expressed it in terms of constraint, and they have expressed it in terms of, in my submission, freestanding causes of action not arising. Now, you can look at that and in my submission, it operates as a constraint, and it should affect the appropriateness or the nature of the equitable remedies which are going to be awarded. This is not, in my submission, an obligation which is simply equivalent to a contractual obligation, because that's not what was being said in the JPO, and it's not what was being said in the Atlantic Conference.
It doesn't matter whether it is or not. What matters
is what is the appropriate response, you might say. Why should, well, I'll come on to the next part of the argument, because it seems to me really that the reasons why it shouldn't be assimilate completely contract related in this context, because in my submission, one of the fundamental rules of contracts, why people are bound by contracts, is privity. And what is happening here is that privity is being completely overlooked. And that is a problem. It's not a defect of the common law, which equity is remedying. It's a fundamental principle of why you make third parties not parties to contract, and you don't grant damages against them. And that is what equity is being used in this situation to ride roughshod over that. And in my submission, there are limits to what equity should be doing. And my second submission on it was that, okay, say there's a substantive equitable obligation to arbitrate, or there is a substantive obligation to arbitrate. What is the consequence of that? And my submission in that respect is that when you're looking at specifically direct action statute claimants given rights under their local law, the manner in which they are accessing the contractual rights is critical. And it's really there when you're getting this clash between EU law and civilian law systems and our law, which is causing the difficulty. And in my submission, there should be a line drawn with the extremity of the equitable remedies which are being afforded in these circumstances. But I'll develop that, but that's basically what I'm going to say.
Can I just put this to you? Let's assume for a moment that I'm right, that the Supreme Court really has got a new view of equity and equitable remedies. The question then is, in what circumstances would compensation be granted for a breach of this obligation in the absence of the ability to grant an injunction? And obviously you would say, okay, it's not the same as a contract, so you don't get contractual damages on the same basis. But you might argue, and you might argue that Lord Justice David Richards even acknowledged that the categories weren't closed, so this doesn't circumscribe it, and certainly what we're looking at in Wolverhampton doesn't circumscribe it. But there has to be some, I mean, I'm now speculating, perhaps there has to be some element of unconscionability. And let's assume that it would be unconscionable for the club not to be compensated for you proceeding in Spain rather than in arbitration. Okay, but then you would say, I assume, something similar to what Mr. Young tried to say on whenever we started this case, Tuesday, to the effect that it's not unconscionable because this is a criminal case, something like you said earlier. This is something that is a sovereign state bringing a criminal case in its own jurisdiction. It's civil law. It would be completely outrageous if they couldn't do that. And part of the civil case is to include civil claims, and if you're including civil claims, you presumably also join the insurer. And so in this case, even if there is an equitable remedy, and even if equitable compensation lies, you would say on the facts that it shouldn't hear. Now, as I understand it, that argument is actually not open to you. Is that right?
No, my lord, that argument is open to me.
It is open.
That is open to me.
No, it's not.
Well, I know Mr. Hancock and Mr. de la Mare are nodding and shaking their heads violently to agree and disagree in turns to what
Exactly. and I was saying that they can I would say, get up and say that and say why it's not open to me. But I'm going to address it as a level of principle, not just tied to the facts of this case. But I have to approach it from direct action cases more generally, because this is only one such case.
If I can help my learned friend, I was shaking my head because of the fact that the issue before your lordship is whether or not there is a power to grant equitable compensation, not how that power should be exercised in the particular circumstances of this case. That would be a question of discretion. That is a question which has been answered by the arbitrators. No application for permission to appeal from the arbitrators in relation to issues of discretion, which obviously would be extremely difficult to obtain permission to appeal on under Section 69 of the Arbitration Act. That does not rule my learned friend out of court in relation to her argument as to third-party assignees being a different category of claimant from assignees or subrogees. That's a more general argument.
But she doesn't rule her out, does it, for saying, yes, you may, even if I'm wrong, or Mr. Young is wrong, and you can get equitable compensation. Equitable compensation, as a matter of principle, can only be granted in the following circumstances.
Yes.
A, unconscionability.
Exactly, which is where I'm going.
Yes.
Yeah. And that wouldn't challenge the actual discretion exercised by...
No, I mean, my
So
point
Peter,
is simple. That's to say, to the extent that the argument is on the facts of this particular case, that's an argument that isn't open to the states. Insofar as the argument is, here are the parameters within which equitable compensation exists, here are the parameters within which the power to award equitable compensation exists.
But,
That's an argument that is open.
I mean, I don't want to keep you on your feet, because I don't want to keep Ms. Dilnot off her feet. But actually, if it's irrelevant, we shouldn't be deciding it, let alone setting out general principles that apply to lots of different cases, because the really key question is, was there power to order equitable compensation? If there was, there's nothing more really for us to say except possibly exercise tread with care.
Yes.
But it doesn't, because there's no appeal from the exercise of their discretion. If there was power and no appeal, then we can say whatever we like and huff and puff mightily, but it doesn't make a difference.
Quite so.
Is that all right?
Yes.
Yeah. Do you think it's right?
No, not entirely. Let's go back to the ground of appeal for which permission
Which page is
was
that?
given. It's the core bundle, tab 27, page 488.
Yeah.
Okay,
Is this-
and it's clearly asking whether
Is
available.
this to the High Court or is this to the Court
This is
of
to the
Appeal?
Court of Appeal. This is the ground of appeal. This is the permission to appeal granted by Mr. Justice Butcher for this appeal to this. I'll just ask the court to. Sorry, could you put it up fully on the screen, please, so that paragraph 1 shows fully.
So it does say, or otherwise to grant it in the circumstances
Of this case.
So we can decide.
Yes, my lord, you can.
Well, whether
I don't know whether it's
power
a matter
to
of-
grant it in the circumstances of this case.
One is allowed to take into consideration what is happening in this case. I'm not challenging the exercise of discretion, the court is permitted to look at the facts of this case and see what has been awarded in this case and why, and to consider whether equitable compensation in that measure and in these circumstances is available.
Well, your lordships have my point. The first question is
It's
what
wider.
permission to appeal was given to the High Court in relation to. What the permission to appeal to this court is irrelevant to that question, because if Section 69 permission was not given, that's the end of the story.
I'm afraid this is the appeal that I sought and obtained from the judge to this court. And we'd have to track back forensically through things.
It sounds as if Mr Hancock's going to do that.
Yes, it does sound like I can hear Mr Thompson revving up already. However, I should just be clear.
I don't have too much difficulty with this.
No, I don't think it's that difficult. I'm not challenging the
If there
exercise
was a
discretion.
power, you don't challenge how it was exercised. You say there wasn't a power in these circumstances to
Exactly.
award equitable compensation.
Exactly, it's not difficult. It's not difficult. And it's why I say I'm entitled.
I mean, I'm afraid I find that much more difficult, because if there is an equitable obligation and there is therefore a breach of an equitable obligation, then I find it quite a short step to say there is power to grant equitable compensation, and a very long step to say how that power should be exercised. And I'm not saying you didn't get permission to, I'm not saying that doesn't encompass the ability for us to speak about it, but I do find it quite difficult, because you're not appealing the facts as such, it's only the law.
It's only the law.
Yeah.
But part of the argument on whether equitable compensation should be available in a case such as this or similar cases is open to me, because
Of course it's
equitable
open.
compensation is not a concept which is just at large. One has to look at what is equitable compensation in the context of a conditional benefit case. That is the question of law before this court. Is it available in a conditional benefit case in relation to this right and this obligation? But that is not simply a binary question when one can then exclude from consideration what the equitable compensation is that could be granted in this context.
We turn it round another way. Think about what the equitable compensation is compensating for. Because if you look at the way that Mr Justice Hophouse, or Lord Justice Hophouse was looking at it, he seemed to, back in 1997, but it's been approved more recently, seemed to appreciate that the remedy was injunctive relief, which in some ways you can say it makes sense because it precludes the mischief, if you like, of getting inconsistent decisions arising in different places. But what is the real consequence of denying compensation in circumstances where that particular ship has sailed? And speaking for myself, I thought when we looked at, was it Airbus or was it, yes, it was Airbus, but the difference of reasoning and the passage that you took us to from the Supreme Court of Singapore's reasoning, which seemed to be somewhat different, wondering whether you were going to capitalise on that or make submissions on the back of that as to what the nature was of the wrong, if you like.
Well, that's what the Court of Appeal of Singapore emphasised the constraint aspect,
yes,
which was consistent with the consensual aspect of arbitration. And so, in terms of, probably hasn't expressed it very well, but I suppose I do say that they are explaining, if you like, what they see as when one talks about a wrong, one is simply looking at a third party who hasn't agreed to do this. Arbitration is consensual. the wrong is acting inconsistently, and the response to the wrong is the constraint, as opposed to the imposition of a liability for damages. And it's a recognition in Rouse and in Singapore, and they're emphasising the voluntary nature of arbitration, and that you have to sort of, the active consent to doing that.
But you say as a matter of principle, the response to the wrong is a form of constraint which would extend possibly to declaratory relief
And injunctive relief.
and injunctive relief, but because they are not actually parties to the contract, they shouldn't be treated as if they were parties to the contract, with all of those consensual rights and obligations that flow from being a contracting party, and therefore cannot be equated for the purposes of bringing them within a damages regime. In other words, there's a balance. There's a balance. You get certain rights, but not others.
Exactly.
Is that
Full
the
panoply, yes, of rights and equitable remedies is not available.
Yes.
Because the right and the obligation is not that which would justify it, if you like. In my experience, that's why it's not, you know, it's why I say there shouldn't be this, or this isn't this assimilation completely between the equitable position and the contractual position. And the authority, well, my lord, there isn't. But also, just in terms of going back to the point about the concern over the scope of permission to appeal, if you like, the ground of appeal quite clearly puts an issue, the direct action statute issue, in terms of whether equitable compensation is available in those circumstances, not necessarily just this case, but a direct action statute case, on whether, leaving aside the point of principle as to what the right is and what it's not, and what remedies are available, if I'm wrong on that and that ship has sailed, the court is able to look and say, is this an equitable remedy which is available in this type of case, as distinct from an assignment or subrogation case? Because they are materially, in my submission, different.
Yeah. You see, if you equiparate damages at common law with equitable compensation, you immediately find that questions of causation and other intimately detailed parts of the right to common law damages. You can take McGregor on damages and take each chapter and say, what about remoteness? What about causation? What about every aspect of the normal common law principles? Do they apply? Now, so the difficulty, you're quite right, in saying we haven't got a privity of contract, but we're going to give damages that look and feel like common law damages, but we're calling them something else, is that difficult. The problem, however, is that the direction of travel in the Supreme Court seems to be to sweep away those kinds of nice distinctions. And what troubles me is that actually what Lord Justice David Richards said was that equitable compensation is something different from common law damages, and it's available in these circumstances. Perhaps I'm not saying that it's never available for anything else, but I'm certainly not saying it's the same as common law damages.
Correct. And that is what he's saying.
But the House of Lords, the Supreme Court now tells us that there should not be a distinction between equity and the common law, and that equitable remedies ought to be available wherever the common law can't provide them.
The problem with this is that it's trying to have it both ways. You say there's no distinction between common law, contract, and equity, and there shouldn't be any distinction. And yet, in this line of authorities, what the courts are doing is using equity to get around the problem of privity. Contract and common law says you cannot do this. And what the courts are doing is saying you can't, you don't fulfill those rules, which are there for a good reason. It's not a defect. It's there for a very good reason about who you bind to contracts. But what we're going to do is impose an equivalent equitable obligation, because we can't bring you within the contractual
But there
concept.
is one, Ms. Dilnot. According to Airbus, which binds us, there is an equitable obligation.
There is an equitable marital obligation.
And you have broken it.
The nature of the obligation, however, my lord, in my submission was explained in the J. Bowler and endorsed by the Supreme Court. It was not given that exposition in Airbus. And the ratio is the relief which is available, declaratory relief is available. The explanation of the conditional benefit principle and the right and obligation advising is explained in the J. Bowler and the Atlantic Confidence. And it is not so straightforward as to say this simply equates to contract. But if the point is put, which is being put to me, the Supreme Court is saying one shouldn't have these distinctions between law and equity. Well, then in my submission, you have to apply the same rules. Contract, you apply an equity. And if someone isn't a party, then the consequences of them breaching whatever obligation it is should not be imposed, because they are not a party. They are not a party to a contract. And if one isn't going to respect the rules of contract, which are there for good reason, in my submission one can't justify importing contractual remedies into that situation.
You can grant an injunction, you can grant a declaration, but if those are useless, that's it.
My lord, I'm afraid, yes, that's right.
But that sort of courts don't like that kind of submission.
I know, but in other cases, in fairness, in other cases, which is not this case, but as a general principle and not tied to the facts of this case, there would be another remedy potentially, although it's never been granted, under Section 50. Because if the court grants an injunction, you can have damages under Section 50 in addition or in lieu. Damages could be granted in addition if someone could persuade a court to their exercise of its discretion in that regard. In this case, it's not, in this case. But in other cases, it would be. Hasn't happened to date. We've shied away from that. I don't believe Section 50 has been used for breach of an exclusive forum clause in equity. But it is there. And that is the court's power, a power which is very obviously there, if needed, to award damages if it can be persuaded as a matter of discretion to do so. However, going down this route, equating it to simply the equitable equivalent of a contract.
So why is Section 50 not mentioned in any of the authorities we've looked at?
My lord, it is mentioned, I believe, by Mr Justice Flo, as he was in West Tankers, very briefly says this may be available for breach of the equitable obligation. And I think it was mentioned by Sir Michael Burton, may or may not be available, but there's no decision being taken as to whether it's available or not. But it would, in my submission, it would be the obviously more profitable route than trying to use equitable compensation. And the beauty of Section 50 would be that the court would be far easier for the court to take into account the justice of the case, because it's a completely discretionary exercise. Because if you follow analysis which says it's equivalent to contract, you just get damages. If someone's breached a contract, damages as a right. That's how it works. No discretion. You import that into equity, the court's hands are going to be tied in other cases to grant damages for breach of an equitable obligation to arbitrate. And why that is so dangerous now is because you have all these direct action statutes out there and criminal procedural statutes in civilian jurisdictions which allow civil claims, including against insurers, to come as part of
not even allow, sometimes it's an automatic consequence. In certain jurisdictions, you start the criminal proceedings and immediately there is a parallel civil action. So if you're going to, you can see that the person who's the injured party is stuck between a rock and a hard place, because on the one hand they've got what is said under the European or other statute is an inalienable right to sue in the country of their own domicile, which has got to be meaningful. And on the other hand, they have this sort of Damocles suspended across over them, which is that if you do that, you're potentially exposed to equitable damages to the other party.
That's right. That's exactly right. And these things can happen automatically. But in my submission, the court has to be aware that with these statutes, you're talking about people in different countries and jurisdictions which are living in a jurisdiction which gives them, as a matter of that law, a right to sue the insurer direct. And perhaps that's also the place where the harm has So that law and that court has a directly proximate relationship and has granted them that right. And what English law is now doing is saying, no, as soon as you access that right under a direct action statute, you're in breach of an equitable obligation to arbitrate. We can get an injunction against you. You can have declaratory relief. And by the way, now you can be made liable for equitable compensation. When insurers have to come over to Spain or France or wherever and argue about it or try and get themselves out. And if you get a judgment from that court, we're going to grant equitable compensation to neutralise it when you try to enforce it in one place or another around the world if it's not honoured. And that is quite an extreme proposition. And unconscionability looms large in all of this. But I would sort of put the contrary proposition. But what is happening is that you have a decision taken by English law on the one hand to protect arbitration, but other friendly legal systems near to ours are taking a different view, which is they want to protect rights of injured parties and to allow them easy procedural rights to claim against insurers. They may or may not get any compensation, but that's the procedural right which those systems are affording. And it's for good reason, and it's entirely rational. In the case of criminal proceedings, everyone can sue or have their civil claims at the same time. Public prosecutor will make the running. The criminal court is going to make findings of fact. You can rely on those findings of fact for your civil liability. And where you've got cases like this, where you've got hundreds of claimants, you avoid the risk of inconsistent decisions, which would otherwise be a nightmare. In this case, there were 200, I'm going to take the court to the order which was made. There are 256 claimants in this case, and there have been 256 awards of compensation. Spain and France are only two of those. And the logic of the approach of English law so far is that each and every one of those beneficiaries of that Spanish judgment, 256 of them, have breached an equitable obligation to arbitrate and are susceptible to an injunction. They're not states, and are going to be, firstly, liable for insurers' costs were they to incur those costs overseas, which they have, in defending the Spanish proceedings. And the judgments which they've got from the Spanish court, well, this court can grant one in an equal and opposite amount. For each and every one. And that is the result of what is being urged on the court in this case. It's quite easy to look at Spain and France and say they've ignored what was said by Mr Justice Hamlin. But it's not a question, and this court is not being asked just to look at Spain and France. It's being asked to look across the piece. And
okay, well, that sounds like a good place to break, with 254 innocent people ringing in our ears. The church clock.
What rise available?